We are living in a world that is, well, it's fundamentally changed. And the data points, they've really stopped being theoretical and have started being, frankly, brutal.
Mm.
Global temperature is now locked in at about 1.1 degrees Celsius above pre-industrial levels. And we just wrapped up a period where, the past 9 years have been the warmest stretch on any verifiable record.
On record, yeah.
And we're not just talking about abstract numbers anymore, are we? We're talking about physical impacts that are immediate, they're visceral. Things like rapidly rising sea levels, glaciers just vanishing.
Right.
The Arctic ice cover shrinking year after year, and these heat waves that are so intense they're literally reshaping urban life, agriculture, everything.
And this is exactly where the pressure point is. I mean, the immediate physical impacts are straining everything. Global supply chains, fragile ecosystems, national budgets. But this is the crucial part. The trust we place in international institutions.
But trust, yeah.
So alongside the environmental crisis, there's this insidious diplomatic crisis playing out. It's the erosion of public trust in global leaders and in the existing mechanisms to actually do something meaningful and to do it fast enough.
People are just demanding accountability.
They are. And they're not getting it from the political process.
That failure in the political arena is, I think, precisely what makes our mission today so vital. This deep dive is all about understanding a critical, really recent turning point in global climate accountability. It's kind of a shortcut to understanding the cutting-edge legal and diplomatic mechanisms that are now emerging to hold states responsible for inaction, for historical damage. We are looking at what we're calling a tectonic shift.
And like all major shifts, it started with a single, focused legal request.
Right.
That's right. The catalyst wasn't a policy paper or another summit. It was the March 29th, 2023, adoption of Resolution A77L.58 by the UN General Assembly.
So what was this resolution?
Well, it was a coalition of states led by Vanuatu, and they were asking a question of the highest global legal authority, the International Court of Justice, the ICJ.
The court of last resort.
The court of last resort. And the resolution simply asked for advisory opinion on what states' obligations are regarding climate change. This single act signaled a profound change. If policy wasn't working to compel action, then the law would have to be called upon to provide that ultimate foundation for responsibility.
And after a lot of deliberation, a lot of input from dozens of nations and organizations, we finally have the answer. And this is the big reveal that I think changes the entire game. On July 23rd, 2025, the ICJ issued its unanimous advisory opinion.
Unanimous.
I have to emphasize that word, unanimous. I mean, for a court that represents such diverse legal systems, geopolitical interests, to speak with one voice on an issue this contentious, that unanimity alone is just extraordinary.
It really is.
And it's what definitively marks this as a tectonic shift in global climate governance.
It's a huge moment. And here is what you need to know as the listener. We will not just cover what the ICJ said about these legal obligations, which, as you just said, is monumental, but how this ruling immediately forced the diplomatic world to find a suitable tool for implementation.
Right.
The court laid the legal foundation, but it necessitates a new, flexible diplomatic approach. And that approach is climate mediation.
Okay, let's unpack this. We've established the urgency, the crisis of trust, and the legal trigger. So now let's get right to the material. If the ICJ is setting a new legal floor for accountability, what did they establish?
Okay, so the ICJ's 2025 advisory opinion, it wasn't designed to create entirely new law out of thin air. That's not what it does.
Right, it's clarifying.
Exactly. It established a powerful new legal floor by clarifying and reinforcing obligations that already existed but were maybe vague or, they lacked teeth when you applied them specifically to climate change. The court provided authoritative guidance on what binding obligations states hold.
So what were the specific legal anchors they affirmed? Because we're talking about foundational legal principles here that, every country, whether they agree or not, now has to contend with.
Precisely. The court confirmed that states have binding obligations under two distinct, really powerful streams of international law. First, there's treaty law.
Okay.
This covers the big international agreements you already know, like the UNFCCC, the Paris Agreement, and critically, the United Nations Convention on the Law of the Sea, or UNCLOS.
UNCLOS. Now, that might seem like a bit of a sidebar, focusing on the ocean, but I suspect its inclusion is vital, especially for island nations, given the direct threat of sea level rise.
Oh, absolutely vital. The ICJ found that obligations under UNCLOS require states to protect the marine environment.
Okay.
So when climate change, which is driven by global emissions, causes ocean acidification or thermal expansion, which then leads to sea level rise that inundates low-lying coastal regions or entire island states.
Then that's a violation.
That is a violation of the duty to protect the marine environment and, by extension, the territory of other states. These treaties, they explicitly create measurable obligations for climate action.
And the second stream of law is often the one people find a bit more complex, customary international law.
That's right. And it's often harder to define because it's not codified in a single treaty document. It represents established state practice, so what countries routinely do, and crucially, opinio juris.
Which is the belief that it's legally required.
It's the shared conviction among states that a certain behavior is legally mandatory, not just, polite diplomacy.
So the ICJ reviewed decades of emerging environmental governance, treaties, bilateral agreements, declarations, all of it, and concluded that a binding climate obligation has now, crystallized as a norm of international behavior.
Exactly. The ICJ opinion synthesized this whole emerging body of work into one clear statement. States have a binding duty to prevent significant transboundary harm to the climate system and the environment. And this duty exists regardless of whether a state has signed and ratified every single climate treaty.
So it's universal.
It's universal. This dual affirmation treaty obligations confirmed by custom, it makes the requirement for responsible action inescapable.
But here's where it gets, I think, really interesting, because the court didn't just talk about environmental duties. They tied it directly to human welfare. They established this critical and immediate link that elevates the climate crisis from just an environmental policy problem to a mandatory human rights concern.
Yes, and this is the most forceful element of the entire opinion. It's what gives it enormous political leverage. The ICJ established that a clean, healthy, and sustainable environment is a non-negotiable precondition for the enjoyment of many fundamental human rights.
A precondition. So if the environment is degraded,
your human rights are structurally compromised. Simple as that.
What specific rights did they cite?
They were very specific. They cited the rights to life, health, and housing.
Wow.
By putting human rights at the center, the ICJ completely reframed the climate crisis. Climate change is no longer just some slow-moving global externality.
No.
It is an active threat to fundamental rights. So if a state's inaction on climate leads to severe heat waves that destroy crops and raise mortality rates, that state is arguably violating the rights to life and health of its own population, or the population of another nation impacted by its historical emissions.
That is a tectonic shift in leverage. It means that climate failure moves from being a diplomatic failure to a verifiable legal violation that can be pursued in other courts, in international tribunals.
Absolutely. And to make this actionable, the ICJ went a step further. They defined what exactly constitutes a failure to act, what they term an international wrongful act.
The legal term for inaction.
It's the judicial translation of inaction, yes.
So give us the concrete, policy-relevant examples that the court pointed to. What actions, which were perhaps commonplace before, are now legally perilous for high-emitting nations?
The court was explicit and very direct. They stated that failures to act, such as the continued licensing of new fossil fuel projects — we're talking coal mines, oil fields, gas exploration — or the persistent subsidizing of fossil fuel extraction, may now constitute an international wrongful act.
That is a direct challenge to the domestic economic policy of most major industrialized nations.
It is. This is the court saying, look, the science is clear. If you are actively promoting or enabling activities that exacerbate damage to the climate system, you are violating your international obligations to protect the rights of life and health globally.
So it completely redefines the risk calculation.
It does. Before this ruling, approving a new coal mine was, politically sensitive. Now it carries recognized active legal risk of being cited as an international wrongful act.
But let's introduce some friction here. Doesn't the ability to license fossil fuel projects still fall squarely under a state's sovereign economic rights? How does the ICJ opinion manage to override that sovereignty?
That is the essential tension, isn't it? And the ICJ handles it by invoking the trail smelter principle, which we'll get into a bit later. But the core idea is sovereignty does not include the right to cause injury beyond your borders.
Okay.
So while a state retains the right to manage its resources, the ICJ ruling clarifies that this right is limited by the binding duty to prevent transboundary harm. So, State X can technically still approve a new oil field.
Right.
If that action is demonstrably inconsistent with the global commitment to keep warming below 1.5 degrees Celsius, And if it harms the human rights of vulnerable communities elsewhere, the ICJ has given the international community the legal leverage to challenge it as a wrongful act.
So it forces states to internalize the global costs of their sovereign decisions.
That's the perfect way to put it.
So if the court has clearly defined this failure to act licensing new fossil fuels as a wrongful act, then we need to know what the required remedial obligations are. What are the mandatory consequences for the state that commits this violation?
Well, when the highest court defines an international wrongful act, the state is required to meet specific, detailed obligations under the international law of responsibility. The court outlined 3 essential categories of remedy.
Okay, what's the first one?
First is cessation. The state must stop the harmful conduct immediately. This is effectively a global cease and desist order. It means halting the licensing or the subsidies that constitute the wrongful act.
Which, as we just discussed, sounds politically almost impossible for heavy-hitter economies that rely on these industries. How can a state just flip a switch overnight without crashing their economy?
And that is the practical challenge, and it's why the ICJ opinion doesn't mandate the how, but rather the what. It requires immediate cessation of the wrongful aspect.
I see.
This is where diplomacy and mediation become necessary to negotiate a phased, verifiable cessation plan that meets the legal requirement while managing economic stability. The legal duty is absolute. The method of implementation is negotiable.
Okay, that makes sense. So what are the other 2 mandatory remedies?
Second, there's the obligation of reparation, full compensation for the injury caused. And we need to pause here and clarify that reparation is much more demanding than just simple damages.
How so?
Reparation, as far as possible, must wipe out all the consequences of the wrongful act. It implies a full restitution to the status quo ante, or, the state of affairs that would have existed had the wrongful act not occurred.
So if a community lost their fishing grounds because of warming waters caused by a state's wrongful inaction, simply cutting a check isn't enough. Reparation would imply the restoration of that environment and that livelihood.
Exactly. It aims for restitution, which can be impossible in the climate context. You can't just undo the warming.
Right.
Therefore, it demands comprehensive measures that are equivalent to full restoration. And third, which is crucial for forward-looking climate policy, we have guarantees of non-repetition.
Which means?
Commitments to ensure the harmful conduct does not occur again. This last point explicitly links legal responsibility with future policy commitments, like specific, verifiable emission reduction targets.
But I'm going to reintroduce the main legal skepticism here. ICJ advisory opinions are traditionally non-binding. So if a state doesn't like the opinion because it challenges their energy policy, why should they comply with cessation or reparation?
That is, the technical legal fact advisory opinions are not binding judgments resolving a dispute between 2 specific parties. But that view is, I think, too narrow. This opinion isn't just some random piece of legal advice. This is the highest court in the world, speaking unanimously, to clarify the existing content of customary international law.
Okay.
The opinion now provides authoritative clarity on those underlying legal obligations.
So even if the opinion itself isn't a binding court order, it validates and reinforces the legal claims that vulnerable nations or affected communities might bring in other forums, whether that's domestic courts or international tribunals. It's massive legal leverage.
Precisely. It shifts the burden of proof.
Yeah.
Any high-emitting state attempting to justify continued fossil fuel licensing now has to contend with the unanimous, authoritative finding of the ICJ. And perhaps most significantly for our discussion, the opinion implicitly recognizes that climate harms are diffuse and systemic, and consequently, it strongly promotes the use of non-adversarial methods for resolving these inevitable disputes.
So it creates
a new pathway for interstate negotiated dispute resolution steering countries away from purely adversarial courtroom battles toward practical mediated solutions.
And why is that shift so necessary? I mean, why can't the ICJ or other courts just stick to the traditional system of damages?
Because the harms are intergenerational and they're systemic. I mean, how can a traditional court, focused on quantifying immediate financial damages, calculate the loss of a nation's habitable land over 50 years?
It's possible.
How do you quantify the collective damage from thousands of emitters across a century in a simple lump sum judgment? The ICJ recognized that the sheer scale and complexity necessitates flexible, comprehensive solutions that go far beyond simple monetary compensation. We need a tool that can blend finance, technology, and long-term governance reform.
And that requires mediation.
That requires mediation.
So we've transitioned from the legal mandate to the practical response. Given the scale and complexity, systemic, diffuse, intergenerational, We need a diplomatic tool that can handle that kind of multidimensionality. You're arguing that mediation, specifically, is uniquely suited to translate the ICJ's abstract legal duties into concrete, actionable policies.
Is the necessary pragmatic and diplomatic tool. And, conceptually, it's entirely consistent with the existing climate regime.
Oh, so?
Well, if we look at the foundational text of climate law, Article 14 of the UNFCCC already provides a basis for amicable settlement and conciliation regarding disputes. So mediation is completely consistent with the cooperative spirit and the differentiated responsibilities that are embedded in international climate law.
Okay, so the source material defines three distinct structural models for how this mediation could be rolled out globally, starting with the most straightforward approach.
The first is the simplest and most focused, bilateral mediation. This pairs a single major emitter state, a heavy hitter, with a highly vulnerable state. You can think of a hypothetical scenario like, say, the USA versus Vanuatu, or maybe Australia versus a Pacific Island neighbor.
That sounds like a direct negotiation, but now the negotiation is no longer purely political. It's framed by these new ICJ legal obligations.
Precisely. The mediator uses the ICJ's ruling, the requirement for cessation, reparation, and non-repetition, as the non-negotiable floor for the discussion. The outcome is technically non-binding, but because the ICJ's legal authority is looming in the background, the public and political potency of that agreement is extremely high.
So non-compliance equals
Massive reputational cost and increased legal risk elsewhere.
Then we step up in complexity to the second model, which I think addresses shared harms.
That would be the Regional Climate Dialogue Table. This involves groups of impacted states negotiating with groups of emitting states, negotiating together. For instance, the entire Pacific Forum negotiating with a coalition of annexed Maya states, or maybe the African Union negotiating with major European polluters.
That sounds exponentially more complex, involving so many more interests. What's the benefit of that?
It's just more efficient because it addresses systemic regional harms rather than these fragmented, isolated bilateral claims. And this model features essential components like joint fact-finding.
Getting everyone on the same page scientifically.
Exactly, getting all parties to agree on the same scientific baseline. And it leads to multilateral commitments and resulting declarations that are often tied directly to outcomes from the annual COP meetings. It formalizes cooperation among neighbors and aligned partners who are facing shared climate threats.
And the final model is the most robust, and it's designed specifically to overcome those enforcement fears we talked about earlier.
That's the Mediation plus Enforcement Covenant. This model doesn't just end with a simple declaration or a political handshake. It requires a binding follow-up agreement.
So the mediation functions as the consensus-building process, and then the agreement that's reached is formalized into a legal document, like a treaty or a covenant.
Exactly. And this covenant includes specific, agreed-upon supervisory mechanisms for implementation, ongoing monitoring, and crucially, a structured path for judicial review.
So it's got teeth.
It allows for possible referral to future arbitration or adjudication if the terms of the mediated settlement are demonstrably breached. This takes the flexible, creative solution that was crafted in the mediation room, and it locks it down legally, addressing the core enforcement fears of vulnerable states.
So let's focus on that primary advantage mediation offers over a courtroom: flexibility. The core premise is that climate harm isn't reducible to just a single cash figure. So how does mediation offer these comprehensive, multidimensional solutions that go beyond, zero-sum compensation?
This flexibility is the core strength, and it aligns perfectly with the ICJ's demand for full reparation. Courts are constrained by rigid legal remedies, injunctions or damages. That's about it.
Right.
Mediation allows for holistic, forward-looking settlements that address the root cause, the immediate harm, and the future resilience, all in one package.
Can you give us some concrete examples of these multifaceted solutions that a mediator can help the parties craft?
Yeah, sure. We can start with adaptation and resilience. Instead of merely demanding cash, a mediated outcome can be designed to pair direct financial transfers or compensation with specific long-term adaptation projects.
Like what, for example?
This could be investment in mangrove restoration, flood defenses, or the development of specific drought-resistant crops. This transforms what could be seen as a punitive payment into a shared partnership for future safety and resilience.
So the settlement isn't just about paying for the past, it's about strategically investing for the future.
Precisely. And furthermore, mediation can facilitate access to critical technology. And this isn't just handing over a piece of hardware. It's about providing clean energy tech, carbon capture capabilities, or advanced early warning systems.
And the know-how to use it.
Yes, coupled with the necessary capacity building initiatives, training local engineers, establishing maintenance facilities, so that developing states can actually utilize that technology effectively. This directly addresses the differentiated capacities recognized under international law.
And what about the immense financial constraints that many vulnerable states face? I'm thinking especially about those dealing with high debt burdens that consume the very resources they need for climate action.
Well, mediation provides the unique political space to incorporate solutions like debt restructuring or relief measures directly into the settlement package. For instance, a mediator might facilitate a debt for climate swap.
We hear that term often, but for the listener, how does a debt for climate swap practically work in this context?
Simply put, it's a contractual arrangement. A creditor nation agrees to erase or restructure a significant portion of the debt owed by a developing nation.
Okay.
In exchange, the debtor country immediately commits that freed up money, which previously went to debt servicing, into a verified, transparent national climate resilience or conservation project.
So it frees up crucial fiscal space.
It does, for the vulnerable state to invest in its own climate action, rather than relying solely on external finance.
That is a powerful demonstration of shared responsibility where one policy instrument, debt, reinforces another, which is climate action.
But critically, mediation allows for those guarantees of non-recurrence, the ICJ's third mandatory remedy, to be designed pragmatically. States can negotiate specific commitments, like hard deadlines for phasing out coal or joint development of improved environmental governance standards.
Right.
This moves the discussion from simply compensating for the past to actively preventing future harm, which aligns perfectly with the ICJ's cooperative vision.
Let's talk about the political reality again. Why would a powerful nation, especially one with a huge domestic fossil fuel lobby, prefer mediation over fighting a lawsuit for years in court?
Because litigation creates zero-sum dynamics. When a major emitter is dragged to court, it's forced into this rigid position of denial or defense. The media spotlight is intense, and any ruling that requires large-scale financial transfers is framed domestically as a national defeat, an admission of guilt, or a penalty on taxpayers.
Which strains relationships.
It inevitably strains bilateral relations, making future cooperation almost impossible.
So litigation is confrontational in public, potentially damaging diplomatic ties permanently.
Precisely. Mediation, by contrast, offers a confidential and significantly less confrontational forum. States can explore core interests, not just legal positions. They can exchange sensitive economic or scientific information and negotiate shared solutions without the public spectacle and the high reputational risks of a trial loss.
It's a political off-ramp.
It provides the political off-ramp necessary for them to save face while meeting their legal duties.
And this approach aligns perfectly with the ICJ's broader philosophical mandate, doesn't it?
Absolutely. The ICJ's advisory opinion heavily emphasized the concepts of shared obligations and collective stewardship of the global climate system. Mediation operationalizes this by allowing states to jointly design implementation mechanisms like cooperative adaptation projects or joint monitoring arrangements.
So it transforms responsibility into collaboration.
It transforms a legal finding of responsibility into practical, ongoing collaboration, preserving those crucial diplomatic relationships.
What's fascinating here is how the court itself, in reaching its opinion, leans so heavily on IPCC findings. This signals that future disputes must rigorously integrate science and policy. Why is mediation better equipped to handle that complex integration than a court?
Well, traditional court proceedings, they really struggle with scientific complexity. You often have dueling expert witnesses, high evidentiary burdens, and judges who aren't necessarily climate scientists trying to make sense of dense, rapidly evolving data.
Right.
Mediation's inherent flexibility allows for direct science policy integration.
Meaning the scientists aren't just witnesses, they're part of the solution design team.
Exactly. Expert mediators, advisory panels, or joint fact-finding bodies can be mandated to produce a single, agreed-upon scientific attribution report that defines the baseline facts. How much did historical emissions contribute, and what specific localized damage resulted?
Okay.
Negotiators then use that agreed-upon science to shape solutions. This ensures the final agreements are based on the best available science, leading to outcomes that are not only legally palatable, but scientifically credible and sustainable in the long term.
And that scientific input ties into the concept of adaptive management, which is so vital in a changing climate. The problem doesn't stand still.
The problem is dynamic, and mediation allows for phased implementation and built-in review clauses. Agreed actions can be revisited and adjusted as new climate data emerges. Maybe a new technology makes deep decarbonization cheaper, or a new attribution study shows an unforeseen regional harm.
So it's a living agreement.
This adaptive process is exactly what the ICJ encouraged, cooperative problem solving that can evolve over time, bridging legal principles with real-world, changing evidence.
Okay, so we've established the why the ICJ created the legal mandate, and the complexity demands flexibility. Now let's move to the how. How do we actually take this legal framework and build a functional diplomatic tool? I mean, we don't have to start from scratch, do we? History must offer some crucial lessons for designing this new process.
We can draw on two major sources of precedent. The first is, well, it's ancient history in environmental law terms, but it's foundational. The Trail Smelter arbitration between the United States and Canada, which ran from 1938 to 1941.
The name sounds almost quaint compared to a global crisis, but what was the core principle established there that still echoes in the ICJ's opinion today?
The dispute was surprisingly visceral. It involved a Canadian smelter in British Columbia that was releasing massive amounts of sulfur dioxide fumes.
Okay.
These fumes drifted across the border and were literally killing farmers' wheat fields, orchards, and trees in the state of Washington. It was causing specific, measurable economic damage.
In the ruling.
The arbitral tribunal held Canada responsible, requiring both cessation of the harmful activity and payment of damages.
So the core legal principle.
It established the enduring principle of international law, that no state has the right to use or permit the use of its territory in such a manner as to cause injury by fumes in or to the territory of another.
Wow.
The ICJ's recent opinion is a massive, modernized reaffirmation of this duty, expanding it from localized fumes killing wheat to global emissions, destabilizing the entire climate system and compromising human rights beyond a state's borders.
The principle holds, but the difference in scale is just vast. Trail Smelter was a localized, single-source pollution event where causation was relatively easy to prove. Climate change is cumulative, multi-source, and global.
Precisely. And the lesson we take is that damage requires cessation and redress. But because climate change is systemic and intergenerational, the ICJ's reasoning suggests that the remedies have to extend far beyond simple damages.
Right.
We have to shift toward cooperative and forward-looking measures, such as comprehensive adaptation finance, capacity building, and systemic technology transfer. The remedy must fit the scale of the damage.
And the second source of precedent comes from the core of diplomacy itself, peace building.
That's right, borrowing from peace mediation. The UN has a long, deep history in political mediation and peacekeeping, often referred to as good offices. This process is designed to bridge deeply rooted political and communal divides that involve complex mixtures of science, political interests, and community welfare. That is the exact blend of issues we see in climate disputes.
So it's a mix of legal claims, scientific uncertainty, and massive political interest.
Exactly.
So it's about taking those process models, inclusive dialogue, neutral facilitation, building consensus in a high-stakes, zero-sum environment, and applying them to climate accountability.
Yes, the ICJ's emphasis on cooperation and good faith engagement mirrors the core philosophy of successful peace mediation. Drawing on these practices helps states move from a confrontational, rights-based legal standoff to a collaborative, interest-based effort focused on joint problem-solving and equitable burden sharing.
It's about managing profound disagreement without resorting to war or adversarial litigation.
That's the goal.
Okay, let's get technical now. If a vulnerable state and a high-emitter state decide to go down this mediation path, they need a clear, structured process capable of delivering those complex multi-track remedies. What is the essential operational checklist, the blueprint for effective interstate climate mediations?
We need 6 essential elements, each designed to ensure the mediation is credible, legally informed, and capable of delivering durable results that satisfy the ICJ's reparative demands.
Okay, starting with element 1, clarity of purpose or scope.
Establish mandate, scope, and sequencing. Parties can't just agree to mediate climate claims. That's too vague. They have to clarify the relief horizon at the outset.
So what's the goal?
Is the goal purely to settle claims for past damage, for reparations? Is it to set future mitigation commitments? Or is it a composite package that blends both? The ICJ opinion widens expectations about reparations, so the mediator has to manage those expectations carefully.
And I imagine sequencing is key to building trust in what could be a pretty hostile environment.
Absolutely. The sequencing should start with a joint fact-finding and trust-building phase, often involving an independent science panel or auditors. They agree on the facts first.
Right.
Only then do you move to negotiating core principles, like assigning probabilistic shares of liability and causation. And you conclude with drafting the specific implementation and monitoring arrangements.
Okay, element 2 is technical credibility. We need the best science right there in the room.
This is non-negotiable. Integrate independent technical expertise. Given the ICJ relied so heavily on the IPCC, the mediation must mandate an independent panel of scientists and economists. We call this a joint scientific attribution panel.
And their role.
Their role is to produce a transparent, credible technical basis for the negotiations.
What exactly are they producing? I mean, how do they quantify this sprawling damage?
They need to produce what we term a meter-by-meter causal assessment and damage quantification. This is critical because it moves the focus away from general climate trends towards specific localized impacts.
Can you give an example?
For example, they might assess the probability that a state's emissions caused a specific degree of sea level rise affecting a particular island, and then quantify the resultant damages in terms of infrastructure loss or forced migration costs. This creates an agreed-upon technical baseline so that negotiators aren't arguing about the science, they're arguing about the response to the science.
Element 3 addresses the need for settlements that powerful nations can actually accept domestically, these politically palatable remedies.
Design multi-track remedies.
Yep.
As we established, the remedies can't be limited to a single punitive payment. We have to package composite settlement packages to increase political palatability and deliverability. This means combining various forms of relief that meet different needs.
Give us the breakdown of this multi-track approach. What's in the package?
It needs to blend direct and indirect support. So examples would include direct compensation, yes, but also a specific climate adaptation and resilience investment plan, maybe building renewable energy infrastructure or water desalination plants.
Okay.
You also include technology transfer, tariff-free access for affected exports into the emitters market, highly complex instruments like those debt for climate swaps, and finally, joint carbon reduction projects that give the emitter credit while verifiable monitoring takes place.
Element 4 is the assurance that the money or resources will actually arrive reliably. The financial architecture.
Financial architecture and phased payments. Credibility requires ironclad assurance. States can't just rely on a promise from a political administration that might change in 2 years.
So what do you do?
Parties should use escrow mechanisms.
For the listener who isn't steeped in international finance, how does an escrow mechanism work in this high-stakes context? I mean, who is the neutral third party?
An escrow uses a neutral, highly reputable third party, perhaps the World Bank, a regional development bank, or a specific UN-affiliated finance institution, to hold the promised funds.
So the money is set aside.
The emitter state deposits the agreed-upon funds immediately into this account. The funds are then only released in pre-agreed tranches, tied to verifiable milestones achieved by the vulnerable state like the completion of a seawall or the demonstrable adoption of new clean energy technology. This decouples the funding from the immediate political whims of the donor state.
And this linkage to existing funds, like the loss and damage fund, that must be crucial here too.
It is. Linkages have to be made to existing funds, particularly the Copycat 27 Loss and Damage Fund and its subsequent operational structures. This provides existing audit trails and governance mechanisms, ensuring transparent and timely disbursement, which is vital for maintaining trust and reliability across decades.
Element 5 is the long-term commitment, ensuring this agreement doesn't just unravel 5 years down the line when the political mood changes.
Monitoring, verification, and dispute avoidance clauses. Every settlement has to embed a robust monitoring system with independent verification. And this includes not just financial audits, but scientific verification.
How do you verify that?
Through specific metrics. Maybe satellite imagery confirming that promised forest protection has occurred, or independent audits tracking emission reductions.
And the dispute avoidance steps.
They're critical. Instead of escalating straight to arbitration, pre-agreed dispute avoidance steps, like mandatory reconciliation boards, technical review committees, or scientific experts, should be engaged first to handle minor disagreements or measurement discrepancies. Arbitration is reserved only as a last resort.
I see.
And importantly, mediation settlements should include built-in review clauses allowing for periodic adjustments based on new scientific data or unforeseen harms.
Finally, element 6 brings us back to that human rights underpinning, legitimacy and inclusion.
Equity, participation, and transparency. Since the ICJ opinion stressed that climate harms implicate human rights, the settlements must have procedural legitimacy. This requires the inclusion of affected communities and small state representatives in advisory roles, or even designating them as third-party beneficiaries of the financial packages.
So the money gets to the people who need it.
This ensures that the solutions are locally appropriate and meet the needs of those most affected.
But how do you balance the necessary confidentiality required for diplomatic success with the demand for transparency from those affected communities? It's a tricky balance.
It's a delicate balancing act. The actual negotiation process have to be confidential. That's what makes mediation work. But the final settlement, especially regarding financial flows and verifiable deliverables, must be subject to public reporting. The agreement should define what information remains confidential, like specific negotiating positions, versus what must be public, like the goals, the funding amounts, and the monitoring results.
So you're balancing accountability with political necessity.
Exactly.
We have the legal foundation and the operational blueprint, but let's be pragmatic. Turning these broad legal principles into functional mechanisms, it's going to face serious hurdles. We need to acknowledge the political and scientific friction points that will challenge the implementation of climate mediation.
Oh, the path is absolutely not frictionless. If it were easy, it would already be happening.
The first major hurdle is technical, and you alluded to it earlier, attribution complexity.
The challenge is fundamental. Climate damage is the result of cumulative, multifactorial processes unfolding over decades, caused by thousands of actors. Harms rarely trace neatly back to a single source. This makes applying traditional legal notions of liability, where you identify a single fault, extremely difficult. If a major hurricane hits, how do you mathematically divide up the blame among the top 20 historical emitters?
I understand we need collective attribution, but for the layperson, how do you mathematically divide up the blame for a hurricane? Is this even practically possible, or is it mostly a diplomatic gesture?
It is absolutely becoming practically possible through advances in climate attribution science. We shift away from the simple legal model of direct blame and toward collective attribution frameworks.
Okay, what does that mean?
These expert panels use climate models to assign probabilistic shares of responsibility based on verifiable data like historical emissions, economic capacity, and cumulative contribution to the global carbon budget. They can say, based on the increased intensity of this storm due to 1.1 degrees of warming, State A is probabilistically responsible for X% of that warming, leading to a calculated contribution of Y dollars in damage.
So it's acknowledging everyone contributed to the fire, but those who provided the most fuel have to carry the greatest burden for the cleanup, quantified by the best available science.
That is the equity principle in action. And this reliance on collective probabilistic attribution rather than pinpointing single fault is consistent with the court's emphasis on cooperation and equity within the UNSCCC framework. It's a pragmatic diplomatic solution to a profound legal impasse.
The second hurdle is purely political economy. Wealthier, high-emitting countries, the heavy hitters, they have massive leverage. They may fear domestic political backlash against agreeing to large-scale financial transfers or compensation packages, especially when they can just drag their feet in court.
This is a significant challenge, and your skepticism is well placed. Mediation sounds nice, but isn't it just a way for the powerful emitter to drag their feet, engage in some good faith theater, and ultimately avoid a binding, potentially larger compensation order from a court? Why would a vulnerable nation trust this process?
Exactly. Why trust a non-binding process?
The answer lies in the ICJ's legal leverage and the power of reputation. The ICJ opinion provides the moral and legal baseline. If a major emitter enters mediation and uses it merely to delay, they immediately damage their reputation on the world stage,
Making them a target.
making them a target for more severe adversarial litigation in other courts, which now have the ICJ's ruling as precedent. The diplomatic incentive is to resolve the dispute constructively.
So how do we mitigate the resistance from powerful states who fear this narrative of taxpayer funding for foreign claims?
It requires creative design packages that appeal to self-interest, not just moral obligation. Framing reparative measures as future investments rather than penalties is key.
Okay.
This means blending technology transfers, offering trade benefits like tariff-free access for affected exports, and ensuring that the high emitters firms get favorable positioning in new green infrastructure projects funded by the settlement. High-emitting countries are essentially investing in future market access, diplomatic stability, and crucial reputational gains.
So you're aligning their legal responsibility with their strategic self-interest.
It reframes the entire discussion from a penalty box to an investment opportunity, and it reflects the court's cooperative vision and the pragmatic realities of diplomacy. If the emitter gains a strategic advantage or mitigates a domestic political risk, they are much more likely to enter and conclude the negotiation successfully.
Even after a negotiation is successful, two major worries remain. Will the agreement be enforced, and will it threaten the state's sovereignty by setting a dangerous precedent? Let's take enforcement first.
The challenge of enforcement. Vulnerable states fear noncompliance. A high emitter may promise billions in 5 years, but what if a new political administration takes power and reneges on the deal, claiming the previous agreement was non-binding? That possibility just breaks the trust required for durable cooperation.
So what's the concrete solution to this enforcement fear?
We mitigate this by deploying mechanisms that create accountability through design, not just political goodwill. As we discussed, this means mandating the use of escrowed funds, where the promised money is placed immediately under the control of a neutral third-party trustee.
Right, the third party.
We also mandate leveraging existing, reliable multilateral finance channels, like the World Bank or regional development banks, which already have established disbursement, audit, and compliance structures.
This ensures reliable fund flow, insulated from the immediate shifts of domestic politics in the emitter state.
It creates a system of credible delivery, which is essential for effective cooperation, and a system the ICJ implicitly recognized as necessary given the air-generational nature of the payments.
And the final hurdle, sovereignty. States are profoundly wary that acknowledging responsibility in one mediation will set a universal, binding precedent that opens the floodgates to limitless claims from every corner of the globe.
The challenge of sovereignty. This is a genuine political anxiety that must be managed. The ICJ advisory framework guides states toward responsibility without dictating a rigid liability model. In practice, settlements have to be meticulously scoped, defining precisely what types of harm qualify, under what specific scientific and procedural standards, and crucially for what finite period.
And what is the diplomatic safety valve used to protect against establishing broader precedent?
Every settlement must include carefully drafted, without prejudice clauses. These clauses affirm that a state's participation in the mediation and the subsequent agreement does not amount to a formal admission of guilt, nor does it establish a binding legal precedent for unrelated cases or other claimants.
So it's a political off-ramp for the emitter.
It is. It balances the court's call for accountability with the political need to protect sovereignty and maintain stability against limitless claims.
So what does this all mean? We started with the crisis of trust and the urgency of this 1.1-degree world. The core argument we've unpacked today is that the ICJ advisory opinion on July 23, 2025, represents a tectonic shift. It has dramatically raised global expectations of legal responsibility and reparation for climate harms, making them mandatory under international law.
And because those harms are so complex, so diffuse and systemic, mediation is not a second-best option to litigation. Mediation is now the frontline tool for delivering durable, technically sound, and politically feasible remedies.
Blending finance, technology, governance.
All of it. Things that traditional courts, constrained by rigid remedies and adversarial dynamics, simply cannot deliver. It's about translating a binding legal obligation into collaborative action that lasts.
For this shift to truly succeed, we need to know where the implementation will actually happen. What are the potential institutional homes best suited to host and facilitate these complex interstate climate mediations?
We see three primary institutional pathways, each offering specific advantages. First, the most legitimate is the UN Secretary General or established UN organs.
Why there?
The advantage here is global legitimacy, political neutrality, and direct access to institutional channels, including multilateral finance and technical support. It's leveraging the UN's existing mediation and peacekeeping capacity.
Second, regional bodies for more localized disputes.
Yes, regional organizations like ASEAN, the Pacific Islands Forum, or the African Union. These are ideal for geographically proximate disputes where regional solidarity and contextual knowledge matter most. Disputes between neighboring emitters and vulnerable states can often be resolved best through regional dialogue, leveraging existing political trust.
And third, for the highest stakes, most legally intricate disputes that require maximum neutrality and rigor.
That calls for hybrid rosters, independent panels of eminent persons, perhaps convened by neutral states or institutions like the Permanent Court of Arbitration or the ICJ registry itself, potentially housed at the Peace Palace.
So that signals a really high political commitment.
It does. And it ensures the utmost legal and scientific rigor for high-profile, complex cases involving multiple major powers.
This has been an incredibly detailed look at how global accountability is shifting from the adversarial courtroom to the collaborative negotiation table. But now, what's the immediate actionable step? What is the concluding challenge for you, the listener, or for practitioners in the diplomatic and legal world right now?
The challenge is immediate, and it's threefold. Make the mediation climate ready. The legal basis is set, but the mechanism isn't fully built yet. Practitioners must prioritize three immediate actions to make this successful.
Okay, action one, rebuild the workforce.
We must build climate expertise. This means developing mediator rosters that explicitly include scientists, climate economists, and attribution specialists alongside conventional legal mediators. The panel has to be multidisciplinary from the start, recognizing that this is a science policy problem, not just a legal one.
Action two, secure the funds.
We need to operationalize finance. Settlements must be securely and credibly linked to UNFCCC structures, specifically the Loss and Damage Fund, and establish multilateral development banks, MDBs, ensuring transparent and reliable disbursement and auditing insulated from political volatility.
And finally, action three, create the templates.
We must pilot cases. We need to start a small, carefully chosen number of interstate mediations or facilitated dialogues immediately, perhaps focusing on island states and neighboring high emitters, to test these phased composite remedies and create practical, successful templates that can be scaled up and adapted globally.
So this signals to the world.
The signals to the world that climate diplomacy is defined not by lengthy courtroom confrontation and zero-sum blame, but by highly structured, scientifically informed, negotiated collaboration. The tectonic shift has occurred. The new work begins now.